It looks like court has wrapped for the day in the Larry Whaley case out of Iowa. This is a case coming out of the northeastern corner of the state. That's part of the reason why we just heard a doctor from the Mayo Clinic in neighboring Minnesota on the stand. He apparently is the medical examiner in a series of, I think he said, 8 counties in that area. Now, granted, these are small counties, but talk about a burden on top of what he's doing in his professional work to have to go around to all these different counties in 2 different states and then ultimately testify. Do
the autopsies and testify. So
yes.
it's a lot. I mean, look, I don't know, how many, if there's other doctors that are doing it as well. I assume they are. I've never seen anything like that, so it's interesting to me.
Yeah, I was wondering what the nearest hospital would be, and apparently it's the Mayo Clinic up in Minnesota. But ultimately, we were talking a little bit before, the medical examiner's testimony was pretty short.
Right.
Because it's really not contested that someone died as part of this shooting, and I was sitting there thinking, well, gee, maybe as a defense attorney I would want to milk some of the facts about the trajectory of the angle and this, that, and the other thing, but presumably some of the ballistics would have cleared that up a little bit, because if you're talking about someone who claims he's defending himself because he feared someone was going to break in and do him harm, it would seem to me that the angle of the shot would be relevant to that.
Right, and I think if there was any stippling or anything around the actual wound, which again I don't think there would be because it went through a door, so I think that kind of wouldn't be necessarily anything that the medical examiner could even answer, because obviously if the prosecution was able to prove that it was at closer range, than one expected, then maybe that would go more towards intent. But I don't think that what he has to say, other than that she died of a gunshot wound to the head, has any more relevance other than simply that she was killed by that gunshot wound.
Yeah, the jury's getting to go home a little bit early in this case. It's about 20 after 3 Iowa time, and it seems like the defense wants to start with a clean slate tomorrow morning.
Sure.
Wise tactic?
It depends on what they're starting the morning with. I mean, if it's something they want them to remember, then it's good to start in the morning. If it's something they don't, then maybe start them tonight, and hopefully their summations are further away from when the testimony comes in.
Could it also possibly be because the defense is going to tool its case after having now watched the state rest?
Well, I think that usually is the case, and I think that it's the defense's job to do that. I mean, I'm not sure exactly what their defense is going to be. I mean, one of the possibilities is that he'll take the stand, but I'm not sure if there's going to be any other potential witnesses that take the stand, or if they're going to recall some of the witnesses that previously testified in regards to something that wasn't hit upon.
Yeah, it'll be interesting to see where the defense goes in this case. I would struggle to defend this guy because I'm just not thinking that it's reasonable to open fire on a door without knowing who's on the other side of it.
Right. But that's when you start to make a decision as to whether or not you want to call him as a witness, because simply hearing his words through a detective don't necessarily give you the emotion that he may have been feeling at the time that these events took place. And even though, the standard is a reasonable person in his position, not just his feelings, but someone in his position, I think that, it might be interesting as part of the defense tactics to get him on the stand if they think he's the type of person that is going to be able to express remorse and also express fear as to what was going down that day, that they may think that might help them with regards to this self-defense claim.
It's a big question to put one's client on the stand, and of course we just watched the Kendhammer case, and in that case a lot of people are just looking back saying there's no way that guy should have taken
the worst moment, right? Mm-hmm.
The stand, and he probably sunk it for himself. His experts didn't really help, but then he sort of dug his own grave in that case. At least that's what the court of public opinion would seem to be. I know that you had different issues with that case.
Well, I thought he sunk himself, though. I don't think there's any question that he did not do well on the stand. I think the issue, and everyone's going to yell at me again about it, is...
So my point is that we'll leave the bygones be bygones.
Please do.
We're in a new trial and a new Julie Rendelman.
I have a whole new outlook in life.
Come in with a different hair color next time or
yes,
something.
Yes, exactly. And glasses, no one will know who I am.
now you're saying this guy needs to go on the stand to explain what was going through his mind.
I didn't say he needs to go on the stand. I
So
said
what's he supposed to do?
I said it would be an interesting tactic on the part of the defense for him to take the stand, because the only real way you can even begin to make out self-defense is through his own words. I mean, the witness that's inside of the house, she's on drugs. She's, not necessarily remembering things that went on at that time. So even though she supports some level of concern that the person that's coming to the door may not be who they say they are, she doesn't bring us to the level of actual self-defense. And so it may, depending on how well the defendant can deal with direct and cross-examination, it may behoove them to put him on the stand and let the jury realize that he's a human being. Again, we talked before, there's a completely innocent young woman that was killed for absolutely no reason. And so sometimes to kind of go against that part of it, the defense may want the jury to see that he's also a human being.
So if you were this defendant, would you testify?
I wouldn't be this defendant because I wouldn't be in that position. So
but if you were,
that's the most impossible question to ask.
No, it's not. I think, look, for
if
the
I was
record,
the defense attorney, and I thought that he was articulate and remorseful and expressive of the fear he was feeling at that time, I may be willing to put him on the stand. Again, it's not such a simple thing. Part of putting a witness on the stand is seeing how well they can do under really aggressive cross-examination. And that's something that the defense attorney dealing with his client would know way better than any of us would know.
That's true. Now, as a former prosecutor, and I know that motivation is buried somewhere deep in your subconscious.
It's there somewhere.
Yes, sometimes it does. So in this case, how would you rip into the guy?
Oh, I don't think well, first of all, I'd have mixed feelings, because as a prosecutor, I'd be happy for him not to take the stand, because I don't think that there's even a basis for justification based on what the jury has right now. In terms of I hate to say ripping into him, but the way to cross-examine him is really to go through the law of justification. And when you go through the law of justification with the defendant not really realizing that what you're doing is going through the law, you're making out for the jury that his actions do not fit into the law of justification. Also, you want to make sure are you laughing that I went like,
well, yeah, you're telling me to talk to the hand.
Right.
I think that's what you just did.
I'm not yet. But also, my husband says I use pigeon hands, pigeon fingers. They make fun of me. Thanks, David. But I don't even remember what I was saying now.
You were talking about subjective versus objective standards legally and how.
Oh, but one of the other big things as a prosecutor is don't be only focused on justification. If he's taking the stand, you want to make out intent to kill. So you want to establish that he purposely fired that gun, that he fired it numerous times, that he understood how the gun worked, and that he aimed it in an area where potentially the person on the other side would be. Because you want to get out that he intended for the person on the other side of that door to not get away with coming in, which means to kill them. And so that's also what the prosecutor wants to do.
Yeah, I think that's a completely reasonable closing argument, if you will. And look, I mean, what's this all boil down to? So what if this guy was in fear for his life when he unloaded or shot the gun? He didn't unload it, he shot it at the door.
Right.
But this goes back to the whole standard of objective versus subjective in the law. Subjective standard is trying to ask a fact finder to get inside the head of the person they're examining. And objective is to look at that person sort of from a 50,000 foot level and say, does this make sense?
Right, is it reasonable for the average person to have done that?
Yeah.
Look, if I'm going into the head of someone who suffers from paranoia and is on drugs at the time, the perception is going to be different than if the average reasonable person steps into that position. Most people in that position are not going to reasonably believe that the person who's unlocking their door is coming there not just to hurt them, but to kill them. Because remember, he's using deadly physical force, not just physical force. So that's where his problem lies.
It seems to me that this case just gets shut down with one sentence. It's not reasonable to fire a deadly weapon through a door without knowing who's on the other side of it. Like, end of story. Because again, we're in an objective standard here. It's that 50,000-foot look.
I agree with you. However, it's is that the question is the reasonable person standard a person not just who in his shoes, but also a person knowing the facts that he knows, i.e. potentially that someone is out to get him or that he believes someone's coming to the house.
The key word there is someone, not everyone.
But, and
so
also
you wait and see who it is.
But it's not a situation where he's receiving texts moments before someone comes to the door saying, I'm coming to your house to kill you. You know what I mean? He doesn't have that kind of, explanation as to why he thought that there was an immediate danger to someone coming to the door. On the other hand, quite frankly, if I was in my home and someone started, playing with the doorknob, I'm going to get myself a bat and stand by my door because no one's supposed to be coming to my house at 3:30 in the morning unless it's one of my family members. So that part exists in this case, and that's something that the defense can at least try to play with.
Yeah, it could. I think that ultimately, though, the fact finder is going to have to look at it here. And if they apply that law, they're going to have to say this isn't reasonable under that objective standard. That's where I think it'll probably end.
Right.
Now, could they look at this and say, let's knock this down to manslaughter rather than second degree? Well, second degree's got a lot of sentencing leeway in Iowa. It's a penalty of up to 50 years in prison.
Right.
It's not life, at least the way I read the statute. So that sounds like it gives the judge an incredible amount of wiggle room.
Right. Yeah. Do you know what the minimum is, though? Is it?
I don't remember if there was one.
Right.
I read it really, really quickly, and maybe I glossed over something.
Right.
But the thing that I latched onto when I was flying through it was up to 50 years. I don't think that it said minimum of anything. Right,
yeah, and I'm sure the judge, if he is found guilty of this, is going to take into consideration many factors, including whether he has a criminal record, and again, the fact that the woman that was killed was a completely innocent individual that died so incredibly tragically and for no reason. So he does have a lot of leeway, but he can, if he wants to, my assumption is give him the maximum.
Class B felony. Maximum sentence for a person convicted under this section shall be a period of confinement of not more than 50 years.
Right, and there's no minimum.
Not within it. I guess the next thing is I'd have to go look at the Class B felony
schedule. I like it when you don't know the answers to the questions I'm asking. It makes me feel very good about myself.
Well, aren't you special?
Yes, thank you.
I don't know everything. I know you do.
I do. I just don't know that one.
Okay, and it's one of these things that it doesn't say it in the statute.
Right.
So it's murder in the second degree. That's what it lays out in the statute. I suppose maybe there's a parameter.
Right, I would hope so.
If you link it to the Class B felony statute, and that would be
it just seems like a judge is given an awful lot of leeway if they can go anywhere between 50 and probation. Seems a little extreme, but I don't know the answer to that.
Yeah, and different states do different things when it comes to sentencing, and trying to match them all up requires reading statutory schemes that we frequently don't get a chance to read.
Right.
So let's continue reviewing some of the testimony from earlier today in this case. We're going to dial all the way back to the beginning of the day, again here on the Law and Crime Network, and we'll listen to some of the testimony of Officer Seth McChesney, who was one of the first ones on the stand this morning.
Mark has stated